So now we start section 210 onwards. So section 210 to 222 we will see. Then we'll see section 513 to 519 and then section 227 to 233. So the subject of this particular session today for this particular part of the chapter, which is module 5, chapter 2, is taking cognizance, limitations to take cognizance of offense, and commencement of proceeding before a magistrate. So section 210 says, so this is basically coming from chapter 15, which is conditions requisite for initiation of proceedings. What are the conditions requisite for initiation of a proceeding? That is where these sections are fitting in the BNSS in chapter 15. So subsection 1 says, in the cognizance of offences by a magistrate, subject to the provisions of this chapter, any magistrate of the first class and any magistrate of the second class, specially empowered in this behalf under subsection 2, may take cognizance of any offence. A, upon receiving a complaint of facts, including any complaint filed by a person authorized under any special law, which constitutes such offence. B, upon a police report submitted in any mode, including electronic mode of such fact. And C, upon information received from any person other than a police officer or upon his own knowledge that such offence has been committed. And subsection 2 says the chief judicial magistrate may empower any magistrate of the second class to take cognizance under subsection 1 of such offences as are within his competence to inquire into or try. So we know this, first of all, basically from our initial understanding and readings from the various sections of the initial part of the BNSS and even from the CRPC, that the magistrate of the second class has a very limited scope of looking into very petty offences. So in case a cognizance of such offences has to be taken, it in this the section says it can be empowered by it can empower any chief by through the CJM. Now, what are the authority to take the cognizance? Who has got authority? So first class magistrate, which is JMFC, and JMC, which is the second class magistrate, both of them have the authority. What is the mode of cognizance which is given to them? Upon receiving a complaint, the magistrate, whoever is receiving a complaint that includes such facts and constitutes such an offense, these kind of complaints could come from a person who is authorized under some special law to make such complaints, or upon a police report which could be having those facts reported, and it is also possible to take a cognizance of reports submitted using electronic mode, because BNSS is now proposing more of the utilization of the electronics medium, and through information of personal knowledge or person other than a police officer, which is also possible. So this section not only talks about how the magistrate, on what mode of communication the magistrate can take a cognizance of such offences. It also shows that in what all situations and who can take the cognizance, and it empowers that the JMC could also be empowered through the CJM to take cognizance of such thing, which is in its competence to inquire and to try also. So this section is basically something which is a first section in that particular area, and it talks about the comprehensive jurisdiction, which is the empowerment of the both JMFC and the JMC. It gives a flexibility to initiate the process upon receiving in all those three subclauses, which is mentioned, subclause A, B, and C, and also it helps empower the JMC to take cognizance of such offences as empowered by the chief judicial magistrate. Let's move to next section. Section 211, which is transfer on application of accused. So when a magistrate takes cognizance of an offense under clause C of subsection 1 of section 210. So what was the clause C? It was something which is coming from non-police officer also, which is considered under subsection C or through his own cognizance also. So when a magistrate takes a cognizance of an offense under clause C of subsection 1, where he is empowered to take cognizance himself, the accused shall, before any evidence is taken, be informed that he is entitled to have the case inquired into or tried by another magistrate also. And if the accused or any of the accused, if there be more than one, objects to further proceedings before the magistrate taking cognizance, the case shall be transferred to such other magistrate as may be specified by the CJM in his behalf. Now, first of all, see, this is something which is a very interesting application of the law in the trials, in the prerequisite conditions to start a trial. And this is a very, very beautiful also provision which talks about where a magistrate has taken a cognizance, but the accused or accused person still have a right to challenge that to be run in that particular uh, court where the magistrate himself or herself has taken a cognizance of. So this is an objection from the accused also, which is also valued very much. Of course, there is a limitation given upon when it can be done. There cannot be a free open hand given to unlimited time, the privilege. But then before the evidence is taken, the person who is been an accused on the uh, cognizance of the magistrate himself or herself, that accused against that magistrate's taking the cognizance also for any reason can um, make a transfer of the case to another magistrate through the application to the CJM. So that is an entitlement. That is not an exception. So he is entitled to have the case inquired into or tried by another magistrate if the accused or any of the accused be objects to the further proceeding. So this is the subject of entitlement. So this is a very beautiful section which talks about the very right and just fair hearing. And a transfer is possible. It is allowed. It's rather than just an exception, it's an entitlement. And when it's an entitlement rather than an exception, it is the wording in the second line. If you say, it says the case shall be transferred to such other magistrate. So it will be transferred. It is not saying the case may be transferred. So that's a very, very strong commitment of the judiciary where the magistrate who has taken himself the commitment, he is also somebody as cognizance. He's somebody who is also, if you see indirectly, is also playing role of a complainant here. In that case, somebody who himself has taken a cognizance to give a fair chance where the person can also call in spite of this being raised by a magistrate himself, that this is something which might be biased in the mind of that magistrate. It should not be tried by the same magistrate, and that is respected. So this is 211 is a very, very important and a very beautiful section, which is talking about transfer on application of accused, respecting to the teeth, to the whatever the best possibility of fair judgment process, fair trial process. Section 212, it talks about making over of cases to magistrates. We have seen this earlier also, but I'll still go ahead for the sake of being part of this video. So any CJM may, after taking cognizance of an offense, make over the case for inquiry or trial to any competent magistrate subordinate to him, which is natural. And any magistrate of the first class empowered in his behalf by the CJM may, after taking cognizance of an offense, make over the case for inquiry or trial to such other competent magistrate as the CJM may by general or special order specify, and thereupon such magistrate may hold the inquiry or trial. So this is something basically which is talking about the authority of the CJM, where any matter which is reported, which is handed over, which for which the cognizant is taking on an application, etc. When they take an offense, cognizance of an offense, they can make over the case for inquiry. So if the CJM takes a cognizance of such kind of offense, he is competent and he is authorized to make over the case to for inquiry trial to any competent magistrate subordinate to him. That's how the hierarchy works. But then there is second part two also talks about subsection two talks also about that JMFCs who are also empowered in this behalf by the CJM can also do the same thing, and they can also replicate the same modus operandi, and they can also, on taking cognizance of such any offense, they can also go ahead and pass it on for inquiry or trial to such other competent magistrate as the CJ might be have given by through a general order. So we have talking about general order, spoken about the general order earlier as well. So general order is something which is a by operational order, which is a process and a rule which is already created through on the in the court through the CJM, or of course through the instructions of the various rules and regulations and of the establishment and of the instructions of the High Court, while special orders might be something which might be coming from some special circumstances or cases. So that is why the first class magistrate is also empowered to ensure to replicate the same modus operandi, where he can also take, if taking cognizance of an offense, may make it over to other advocate, other magistrate whom he can pass it on as per the empowerment given by the CJM. So this is basically a technical section which talks about distribution of the work between the CJM and the subordinate magistrates or the JMFCs uh, to the other competent magistrate. So these are technical. This was a technical one, which is basically for used for the operational perspective of the court. Now, section 213 talks about cognizance of offense by court of session. Now, except as otherwise expressly provided by this Sanhita or by any other law for the time being in force, no court of session shall take cognizance of any offense as a court of original jurisdiction unless the case has been committed to by a magistrate under this Sanhita. So it is very clearly, we have seen this earlier also, that restrictions of an to be an original jurisdiction, that is which is prohibited. So this is says that sessions cannot take a cognizance of any offense as a court of original jurisdiction unless the case has been formally committed to it by a magistrate, which is ensuring a very, very clear distinction between the role of the lower court with the magistrates and the higher court where the session judges are there. And the exception which is worded at the very first word of the section is exception word is also used, where the provisions that states that this basically it can only be waived of these conditions if any law currently in force is expressing otherwise. So there might be specific circumstances of law that can call the court of session to assume the original jurisdiction without prior commitment from magistrate, which we know earlier also we have studied that these are the higher order crimes which might be directly having a jurisdiction to being the original jurisdiction in the session court. For example, POXO, rape, first degree murder, etc., etc. So this is basically nothing, again, a technical section which talks about the hierarchical judicial system about and where the lower court does a due diligence to send it across what is actually valid to send to the upper court, so that those courts are not jammed unnecessarily for such important cases, only have to be handled there. So it's an order which is provided, although there is an exception which talks about there are laws and sections under which acts and laws where under which it could be the original jurisdiction also for the court of session. So, but naturally, if 213 exists, 214 will automatically exist. So, through the session judge. So, when the cases come where do they come? They come to the session judge. They're addressed to the session judge. So, 214 says the additional session judges to try cases made over to them. So, an additional session judge shall try such cases as the session judge of the division may, by general or special order, make over to him for trial, as the High Court may, by special order, direct him to try. So basically, the guidelines are woven and inspected by the High Court. They are instructed by the High Court, and then it's a similar model when we talk about the CJM can pass it on to the subordinate magistrates. Very same way, the session judge, whenever it is reported to him, his office, and then he takes a cognizance of those cases. Those cases he will try through the additional session judges, and to which he is empowered as per the general and the special rules which are makeover uh, for the such trial and inspection, and as per the High Court's instruction. So that is how it is done. And we know that the additional session judges are uh, administratively, work distribution perspectively reporting to the session judge, but in the hierarchy perspective, they report to the CJM. Now let's move to section 215. So prosecution for contempt of lawful authority of public servants, number one, or number two, for offences against public justice, and number three, for offences relating to documents given in evidence. So this section is about three things. This is about a prosecution for contempt of lawful authority of public servant, offences against the public justice, and relating to documents given in evidence. So subsection 1 says, no court shall take cognizance A of any offence punishable under section 206 to 223 of the Bharatiya Nyaya Sanhita. So any offence which is punishable under uh, the BNS subsection 206 to 223. So these are also not have to be taken in cognizance by any of the court. Number two, of any abetment or attempt to commit such offence, or of any criminal conspiracy to commit such offences, except on the complaint in writing of the public servant concerned, or of some other public servant to whom he is administratively subordinate, or some other public servant who is authorized by the concerned public servant so to do. B says, one, of no court shall cognizance of any offence punishable under any of the following sections of the BNS, namely section 229 to 233, 236, 37, 42, 48, and 267, when such offence is alleged to have been committed in or in relation to any proceeding in any court, of any offence described in subsection 1 of section 336, and or punishable under subsection 2 of section 340 or section 342 of the said Sanhita, which is BNS, and when such offences is alleged to have committed in respect of a document produced or given in evidence in a proceeding in any court, or of any criminal conspiracy to commit, attempt to commit the abatement of any offence specified in subclause 1 and 2, except of the complaint in writing that of that court or by such officer of the court as the court may authorize in writing in his behalf, or some other court to which that court is subordinate. So number one is talking about that any offence which is part of 206 to 223, which is the chapter 13 of the contempts of the lawful authorities of the public servant. So whatever is listed there, for all those offences, it cannot take a direct cognizance, or even for an abatement or attempt to commit such offence, or such kind of criminal conspiracy to commit such offence, until and unless this is coming from a public servant who is concerned, or coming from some other public servant who is a senior to him, to whom he is subordinate, or some other public servant who is authorized to observe that and go ahead and report that to the courts. So, through the government gadget. Now, the part B says, again, no court shall take any cognizance of any offence punishable under any of the sections which is 229 to 233, which is related to false evidence and offences against public justice related. So 229 to 233, both included. This is something which no court has to take a cognizance of. Apart from that, in the same chapter, section 236, 237, 242 to 248. So basically, taking any kind of fraudulently taking any decree, any false charge of offense, harboring a offender, or these kinds of fraudulently serving decree, etc. So these things also cannot be taken cognizance directly, as these are something which is has to be either reported by the court or by such officer of the court who is authorized on his behalf to write in writing, or some other court to which the court is subordinate, or maybe some of the court of the higher order can also go ahead and challenge that, can ask for that, sorry. So those things are specified. Why these are specified? Because these are operated through these public servants. So these public servants will be actually somebody who will be directly impacted in such situations. And it makes complete sense that this, for the sake of the proper justice system to operate, it is coming from no other than them. So in that case, it has to come from them. And again, the part two, which is related to the procedures inside the court for so and so reasons, which is mentioned under the section 229 to 233 about the evidences, etc., or something related to the decree or the judgment or the evidence taking, etc., for the BNS. So all those things can only be actually reported through the those courts, because that is something which is happening within the court, and it's a byproduct of those things happening in the court. And definitely nobody third party can have an offense, can have a right to talk about those things. And for subsection 336, clause 1, 336, and 340, 342, etc., also, when these offenses are there, then it has to be following the same route. So what this section is, section 215 is telling in nutshell is, this is a two kinds of offenses which are described. One is the public servant related offenses. What is this? No, public servant related offenses, and then offenses related to court related offenses. So in those cases, the subsections are divided into broadly two part, A and B. In case of public servant related offenses, it has to be directly, cannot be taken directly and cognizance of. It has to be through the public servants itself, whether himself or somebody senior to him or her, or somebody is authorized to do that. While the subsection 1B talks about something which is related to court. So, which has to come only from the court. So tomorrow, if you claim a perjury where somebody is your opponent from the other side, who is somebody, uh, bringing some fake evidences in the court, making some false statement to the court, will you go back and put a complaint to another magistrate regarding the what is happening in that court? No. What will happen is, you will go ahead and you can make a request to the same court, and the same court will then make a complaint in writing to some other magistrate to make an inquiry in such conditions, and then this is how it will operate. So this is a very clear-cut regulation given under this section on operating these kind of situations where it is coming for a public servant, or it is something which is coming for a courts related matter, and it has to be bounded to be only originating from the such sources only. So this is again something which is, if you have something which is against a public servant, so which is offenses punishable also for the contempt of the lawful authority of a public servant, where the public servant's authority has been challenged. And there are those sections which are given 206 to 233 in BNS, excluding section 209. So all of these are completely in the scope of through these people only. Otherwise, no. So let me quickly read a couple of sections for you. So 206 to 223, how does it look? So absconding to avoid service of summon, preventing service of summon, non-attendance in obedience to an order from a public servant, etc., etc. So 209 is excluded because that is part of the proclamation. That is again directly which is operated by the court only. So there is nobody need to complain about that to the court. So in all such cases, when there is a contempt, it is part 1, and for court related is section 215. And this is something which is encouragement of the accountability and proper grading of the such special situations where the respective authorized people can only come back and complain for a cognizance to be taken in the court. Moving to section 216, procedure for witness in case of threatening, etc. So this is a section which says a witness or any other person may file a complaint in relation to an offense under section 232 of Bharatiya Nyaya Sanhita 223. So this is a section which provides a mechanism for a witness or any other individual to file complaints regarding the specific offense under section 232 of the BNS, and particularly those related to intimidation, undue influence in the judicial proceedings. So somebody which is obstructing the delivery of the justice and committed a crime which is listed under section 213 of Bharatiya Nyaya Sanhita, which is threatening or any person to give false evidence. So if somebody is putting such kind of pressure to under section 232, which is section for forcing somebody to put a undue give a false evidence. So the person can file a complaint in against this particular situation. So these people can go ahead and take the relief. The scope is given clearly as it is in section 232. And so this is a section which is nothing but the protection for the witness. So protection of the witness, if they are anyway forced to do something in other way around, they are given this protection. Now, section 217. So prosecution for offences against state and for criminal conspiracy to commit such offences. So these are very special situations when we talk about the prosecution for offences against the state and for the criminal conspiracy to commit such offense. So no court shall take cognizance of what happens in this situation. Basically, if you see, no court shall take a cognizance of subsection 1 says any offense punishable under chapter 7 or under section 196, section 299 or subsection 1 of sedition, subsection 353 of the Bharatiya Nyaya Sanhita. So whatever is given in chapter 7 onwards, 7 or under section 196, etc., which is nothing but the offenses against the state, which is listed under section 7, and then promoting enmity between the different groups or on grounds of religion, race, place of birth, etc., which is 196, and then talks about section 299, which is read as a section talking about deliberate and malicious act intended to outrage the religious feeling of any faith and belief. So no court shall take in cognizance of number A. Number B, a criminal conspiracy to commit such offense or any such abatement as is described in section 47 of Bharatiya Nyaya Sanhita, except with the previous sanction of the central government or the state government, which cannot be done. So what is 47 section? Abatement in India of offences committed outside. So this is something which is any abatement as per section 47 also will not be taken notice by the court, because this has to be only done only on instructions from the previous sanction of the central government or the state government. Part 2 says, no court shall take cognizance of any offense punishable under section 197 or subsection 2, subsection 3 of section 353 of the Bharatiya Nyaya Sanhita. So section 197 says it is around imputation, assertions prejudicial to national integration, something related to national integrity. And then section 353, which talks about the statements conducing to public mischief. So no court shall take cognizance automatically for this, or a criminal conspiracy to commit such offense except with the previous sanction of the central government or the state government. So these are pretty sensitive issues. We have spoken about this earlier also. They're pretty sensitive issues, and there should be directives given by the state around this, and that is why it is followed. Subsection 3 says, no court shall take cognizance of the offense of any criminal conspiracy punishable under section 61 of the BNS, and that other than a criminal conspiracy to commit an offense punishable with death, imprisonment of life, or rigorous imprisonment for a term of 2 years or upward, unless the state government or district magistrate has consented in writing to the initiation of the proceeding, provided that where the criminal conspiracy is one which the provision of section 215 apply, no such consent shall be required. So what it says is, the plain reading of conspiracy, criminal conspiracy, is something which cannot be, courts cannot take a cognizance of that. It is prohibited until and unless that criminal conspiracy is done something which is for an offense which is punishable by a major crime, which is something like death or imprisonment for life, rigorous imprisonment, etc., etc., and that has to be or upwards uh, to these kind of terms. So unless and unless the state government or district magistrate has consented in writing to do that, provided that when the criminal conspiracy is one, which the provisions of the section 215 apply, no such consent is required. So any kind of contempt related to the authority of the public servant, where under 215 the person is refusing to sign any statement which he lawfully is supposed to sign. In those cases, as this is a technical problem, where it is automatically pointing to the abatement of the public servant's lawful authority. That is why there is no written permission from district magistrate, etc. is required, or the consent is not required. Otherwise, for all other cases, until and unless it is not a very large crime or a heinous crime, the court will not take a cognizance, which the section 217 says. The subsection 4 says, the central government or the state government may before according sanction under subsection 1 or subsection 2, and the district magistrate may before according sanction under subsection 2, and the state government or the district magistrate may before giving consent under subsection 3. So we have seen all these sections. We have these people giving us a sanction. Order a preliminary investigation by a police officer not being below the rank of inspector, in which case such police officer shall have the power referred in the subsection 3 of section 174. So basically what it says is, so we see the state government and the other parties like the central government or the collector in this situation, who are officially allowed to provide us sanction into this. So these people, before even giving a consent, they might ask for a investigation by a police officer who is not at below the rank of an inspector. In this case, the such police officer will have the powers referred to in subsection 3 of section 174, where the under this power, where the police officer is also given a power to investigate under a non-bailable offense also. So that is why, irrespective of this being something which might not be a cognizable offense also, but the inspector who is part of this particular under this section allowed to investigate has automatically been given such power. So cognizance restrictions are given in subsection 1 and cognizance restriction in subsection 2 also given, where the additional cognizance restrictions are given. So on what conditions it cannot be done. Further restrictions are then given in subsection 3, where in so and so cases, the under conspiracy also, until it is something which is very big and heinous, you cannot take a crime, with an exception where it is something which is in not being obedient to the public servant and somebody is doing that by not signing such document, which is challenging the authority of a public servant. While the preliminary investigation subsection 4 says, before granting sanction or consent. So the state or the central government grants the sanction or the magistrate gives a consent. They can also go back for a preliminary investigation, which is a very good approach where it is not getting into the bias or unlimited providing unlimited and undesirable authority to an officer by streamlining the judicial process by putting a report from a investigation so that the state or the central government can also align that this is exactly what is being violated or is being something which comes under the scope of this particular consent or the sanction, or in that case a district magistrate also could be very much sure that and there is a supporting evidence on why he is providing or not providing a consent. So this is something which is a governmental oversight which is added the primarily for this particular section. Protection from a such kind of state interest and the judicial integrity and efficiency is also established by subsection 4, where a procedure of investigation by a police officer, senior police officer of the rank of a inspector is sort of. Now, let's talk about section 218, the next one. Prosecution of judges and the public servant. So because of a lot of the news in the media, this is a very interesting section to read. So prosecution of judges and public servant. Subsection 1 says, when a person who is or was, is and was both, who is or was a judge or a magistrate or a public servant not removable from his office save by or with the sanction of the government is accused of any offense alleged to have been committed by him while acting or purporting to act in the discharge of his official duty. No court shall take cognizance of such offense except with the previous sanction as save as otherwise provided in the Lokpal and the Lokayukt Act 2013, 1 of 2014. So this is a very first condition given in this particular section, which says that there is a cognizance restriction for such things which are happening where while acting or purporting to act in the discharge of their duty, these people who are or who were a judge or a magistrate or a public servant who is not removable without the sanction of the government. If it is they are accused, in that case, no court shall take a cognizance of such offense. There is a restriction on that, and except with the previous sanction otherwise provided in the Lokpal. So there is a sanction provided there and nothing beyond and apart from that can be utilized. So offenses which are specified in the sections, say chapter 7, etc., etc. In the 1 of 2014 of Lokayukt Act is something which is very, very clearly mentioned in this particular thing. So there is a concurrence which is given by the central government or state government under that particular act, and that only has to be utilized. Subclause A says, in the case of a person who is employed or as the case may be was at the time of commission of this alleged offense employed in connection with the affairs of the union of the central government. Number 2, in the case of a person who is employed or as the case may be was at the time of commission of the alleged offense employed in connection with the affairs of the state government. So no court shall take cognizance of such office except with the previous sanction, save as otherwise provided in the Lokayukt Act 2013, 1 2014, in case of a person in affairs of the central or the state of affairs of the state when they were employed while the commission of this particular offense, provided that where the alleged offense was committed by a person referred to in clause B in state during the period while a proclamation issued under clause 1 of section 356 of the Constitution was in force in a state. So the state was being ruled by the central government's control. And clause B will apply as if for the expression state government occurring there in the express central government. So that point of time, it says read the state government. The B will be simple meaning all the state officials who were in the affairs of state would be considered as the being in service of the center. Provided further that such government shall take a decision within a period of 120 days from the date of the receipt of the request of sanction, and in case it fails to do so, the sanction shall be deemed to have been accorded by such government. So this is for one proviso. Second proviso says, provided also that no sanction shall be required in case of a sexual related crime or something against the nation. Subsection 2 says no court shall take cognizance of any offence alleged to have been committed by any member of the armed forces of the Union while acting or purporting to act in the discharge of their official duty except with the previous sanction of the central government. The state government may be notification direct that the provision of subsection 2 shall apply to such class or category of the members of the forces who are serving in the state, and that will be the word from the subsection 2 will be replaced will be read the will be a subsection will apply as if the expression central government occurring there in the expression state government were substituted. So the same application of the subsection 2, it means its subsection 2 will be applicable there also. Subsection 4 says notwithstanding anything contained in subsection 3, no court shall take cognizance of any offence alleged to have been committed by any member of the forces charged with the maintenance of public order in state while acting or purporting in the discharge of his official duty during the period, or while a proclamation issued in those cases where the center is ruling the state. Subsection 5 says the central government or the state government may determine the person by whom, the manner in which, and the offence or offence for which the prosecution of such judge, magistrate, or public servant is to be conducted, and may specify the court before which the trial to be held. So this section is something which is outlining the procedure and requirement for to prosecute the judges, magistrates, and public servants in relations to offences which have been committed during the discharge of the official duty. And the first part talks about if they are part of in the affairs of the central or they are part of the state, in case the state was ruled at that point of time under the proclamations condition, then they will be considered part of the central government, while there is no sanction required for any kind of offenses which are sexually oriented or serious crimes related to the integrity of the nation. So subsection 1 is talking about basically the people who are part of central state government. There are, in case of special provision, they will all be considered central government. And the timeline of the sanction is also which is given in the first provision in section of subsection 1 says that the government is required to make a decision regarding the sanction within 120 days of receiving the request. If no decision is made with this time frame, the sanction is deemed to have been granted. So it is automatically granted. An exception is which we talked about. Of course, subsection 2 talks about cognizance for armed forces members. Subsection 2 talks about that there is no cognizance while in their line of duty if they're doing. Notification for the state forces is also read as per the subsection 2, replacing the word central government as the state government, which means it is exactly similar way applicable. Subsection 4 talks about basically limitation during the state emergency situation where it is being ruled by the central government, and no state shall government will take a cognizance of such offences by forces if they are doing something during this situation and they are working into the managing the public order, while the subsection 5 is the section which talks about determination of the prosecution, where the central or the state government will determine who will prosecute a judge, magistrate, or public servant, and outline this manner of prosecution, etc., which is specified, which will specify the offense and the designate the court where the trial will take place. So the government will designate that, and this provision centralizes the prosecution process, ensuring that it is aligned with the government policy and oversight, because this is a very serious situation where we are also talking about the integrity of the judiciary to ensure they are not in a they are not handled uncarefully. And then again, about the the armed force personnel who are supposed to be handled with dignity and with great care, because in the line of duty, what they do sometime is not in their control also. And but there is a clear instruction given in this section that there is no such rule, there is no such bar or sanction required in case of sexual offences and crime against the nation. And there is a time period which has to be followed. It cannot go on through unlimited time period, because this will again obstruct the public servant and the judges to be operative during that duration. So this is a legal protection given, but there is a way out given as per the central and the state government, how they operate to designate who will prosecute them. And this will also greatly maintain the independence of the armed forces and the judiciary. Section 219, which is prosecution for offense against marriage. So no court shall take a cognizance of any offense punishable under section 81 to 84, both inclusive, of the Bharatiya Nyaya Sanhita 2023, except upon a complaint made by some person aggrieved by the offenses. The nobody else can go and file that particular. So that is which is given as per the BNS section 81 to 85. So that is one, provided that where such a person is a child or is of unsound mind, or it is somebody having an intellectual disability requiring higher support needs, etc., etc., those people where the requiring higher support needs or is form of sickness or infirmity, unable to make a complaint, or is a woman who, according to the local custom manners, ought not to be compelled to appear in public, some other person may, with the leave of the court, make a complaint on his or her behalf. So basically, let's see one and A, say subsection 1 and subclause A. So one is, this is a clear bar on the courts to take a cognizance of any offense. The very first section says from 81 to 84, inclusive both of them, and it can only be a complaint which is made by the person who is aggrieved by the offense, which is some sections 81 to 84 read is, it's about the cohabitation caused by man deceitfully inducing belief of a lawful marriage. 82 talking about the marrying against again during the lifetime of the husband or a wife. 83 is marriage ceremony fraudulently gone through within the without the lawful marriage, and enticing or taking away or detaining with criminal intimate a married woman. So 81 to 84 inclusive. 84 is little different. We'll talk about it. So subsection subclause A then says this is the ground rule. But then what if the person is not able to make a complaint himself or herself in these special cases? Then it is always allowed to be done by somebody who is the other person who is coming forward to help them, and but with the leave of the court. The person has to first make an application to the intent to the court saying this has happened and I am for so and so reason. The person in violation of the section 1 is somebody who cannot, being the aggrieved person also, cannot make the complaint by himself, herself or himself. In that case, I am somebody who has to, for so and so reason, be represent that person and stand for him. And in that case, the permission of the court, which is leave of the court, has to be taken, and then they can make the complaint on his or her behalf. As I said, section 84 is little different, where somebody is enticing a married woman, taking away a married woman through trick and cohabiting with the person. So that is also something given in subsection C. We'll talk about it later. Subsection V is where the such person is a husband and he is serving in any of the armed forces of the union under conditions which is certified. He cannot take a leave. In those cases, some other person authorized with this person in accordance with the provision of subsection 4, which is coming later, may make a complaint on his behalf. So that person can take a on his behalf the matter. C says where the person aggrieved by the offences punishable under section 82 of the Bharatiya Nyaya Sanhita is the wife. the complaint may be made on her behalf by her father, mother, brother, sister, son or daughter, or by her father's or mother's brother or sister also. So in all those cases, where in case of the bigamy, the so and so people can also make a complaint on behalf of the lady. Subsection 2 says, for the purpose of subsection 1, no person other than the husband. So, of course, 84 is different, where the wife is being enticed and taken by somebody else. The complainant can only be a husband. Subsection 3 says, when in any case falling under clause A of the proviso of subsection 1, the complaint is sought to be made on behalf of a child or a person of unsound mind, a person who has not been appointed or declared by a competent authority to be the guardian of the child or the person unsound mind, and the court is satisfied that there is a guardian so appointed or declared. The court shall, before granting the application for leave, cause notice to be given to such guardian and give him a reasonable opportunity of being heard. So this is something where a very quick precaution is taken by the court to check that if the person who is representing right now is actually representing, because the representations might be also faulty and might be against those persons also probably, and that has to be validated. So why the person who is, if somebody is available, who is a reasonably appointed or declared guardian of those people, if those people are not available, and why they don't want to be heard. So those people are given an opportunity to be heard, and then the court will first make an inquiry and understanding on if the person who is coming now has to be given the leave for representation. Number 4 is about the military officials being the aggrieved party, where it shall be in writing and shall be signed, otherwise attested by the husband, who is the aggrieved party, and shall contain a statement to the effort that he has been informed of the allegations upon which the complaint is to be founded, and shall be countersigned by the commanding officer, and shall be accompanied by a certificate signed by the officer to the effect that the leave is not possible for this person. Subsection 5 says any document purporting to be such an authorization and complying with the provisions of subsection 4, and any document purporting to be certificate required by that subsection, unless the contrary is proved, is considered genuine. And subsection C6 says no court shall take cognizance of an offense under section 64 of the Bharatiya Nyaya Sanhita, where such offense consists of sexual intercourse by a man with his own wife, and the wife being under 18 years of age if more than 1 year has elapsed from the date of commission of that particular offense. So this is about marital rape. So that is not entertained, and that is what the condition is given in subsection 6. So section 219, what we have just read, is something which is a legal framework for the prosecution of the offenses related to marriage, and stipulating conditions for cognizance, representation, and specific provisions for vulnerable individuals. So this is what is overall section 219 talking about. So it does gives a overall framework, but then it also gives a protection to the vulnerable party or the parties who might be losing the opportunity because of the legitimate absence. For example, the armed force personnel who could not come and contest because of his legitimate no possibility of coming and representing by himself due to no leave of absence, etc. So this is section 219. Let's move to section 220. So this is prosecution of offences under section 85 of Bharatiya Nyaya Sanhita. So this is something which is specifically for the section 85 of the Bharatiya Nyaya Sanhita, which reads that husband or relative of husband of a woman subjecting her to cruelty. So no court shall take a cognizance of an offence punishable under section 85 of the BNS 2023 except upon a police report of facts which constitute such offence, or upon a complaint made by the person aggrieved by the offence, or by her father, mother, brother, sister, or by a father's or mother's brother or sister, or with the leave of the court by any other person related to her blood marriage, or adoption. So basically 220 is something which is the section established to a procedure for the prosecution of offences punishable under section 85 of the BNS, outlining how and by whom the complaints could be initiated. So it says there is a cognizance restriction. So no court shall take a cognizance of such offence which is under 85, except the cognizance can be only taken only on a police report of fact which constitutes such offence, complete complaint from the aggrieved party who is actually aggravated by commitment of such an offence, or by her family members who are described in this particular section, or persons with the leave of the court who are related to blood, marriage, or adoption. So any of such people can make a complaint in this case under 85, and then only the courts can take a cognizance. Otherwise, there is a bar for take a cognizance automatically. And why this is required? Because these are the private matters also. So in such family and the private matters, it is a requirement for a verifiable evidence. Nobody except under the four walls, or in case the police has got a chance to look into it through some complaint. In those cases, this family involvement in this complaint is something which makes a sensitive and makes it very specific on the parties who could actually make a complaint, and still giving an access to the justice with the necessary precautions. Section 221. Cognizance of an offense. So basically, no court shall take a cognizance of an offense punishable under section 67 of BNS, where the person are in a marital relationship, except upon prima facie satisfaction of the fact which constitutes the offense upon a complaint having been filed or made by the wife against the husband. And section 67 talks about sexual intercourse by husband upon his wife during separation. So when the separation is happening, in that duration, if it is a forcible sexual intercourse done. So no court shall take a cognizance of these matters where the persons are in a marital relationship, except upon prima facie satisfaction of the fact which constitute the offense upon a complaint being filed made by the wife, who is the aggrieved party against the husband. So this is basically following the same rule of a complaint only by the aggrieved party, with the nature of the very private nature of the complaint. Because what is happening beyond, within the four walls of the family. So that is why this is something which has to be, cognizance restriction is there, but a requirement for a prima facie satisfaction of the court is required when the complaint is made. So when the court has to take a cognizance, there must be a prima facie satisfaction of the facts which are constituting the offense. This means that the court must also find such sufficient preliminary evidences, including that an offense may have occurred. So there should be some preliminary information required to indicate that have occurred, and which serves as a safeguard against frivolous or unsubstantiated claims also. Because in a lot of family matters, this is quite a chance that the people will come back and make false allegations against each other like any other complaint. But this is being a very private in nature. There is hardly any possibility of any third party witness, and who is not an interested witness, to be available in those cases. So that is why it is purely from the aggrieved party, which is the wife, of course, in this case, and then it has to be given an indication, some kind of preliminary indication, something has happened earlier, there is a sour relationship, and there is such kind of reputation, or the incidents, evidences around of the person being of that kind of nature, or the person is of nature of very aggressive nature, etc., etc., is there. So this is a protection of a marital relationship and avoiding any frivolous complaints, but it also empowers aptly the aggrieved party. But yes, it is a bit difficult at times to prove. Section 222, which is the last one in this section, in this series, where we are doing in taking cognizance sections under chapter 2 of module 5. So, prosecution for defamation. So defamation also follows the same pattern, and that is why it is listed here. So subsection 1 says, no court shall take cognizance of an offense punishable under 356 of the Bharatiya Nyaya Samhita, except on a complaint made by some person aggrieved by the offense. Because you will only determine that you are defamed or not. Nobody else can take a decision depending upon something which is said against you. You might be very happily accepting that also there is no problem to you. Then who is the third party to come back and complain about a defamation? It's you only who can make that complaint. So these things are also sometimes a very strong defense line. So provided that where such person is a child or is of unsound mind, vulnerable people now we're talking about, is having intellectual disability or is from sickness or infirmity unable to make a complaint, or is a woman who is according to law not to be compelled appear in public, and some other person may with the leave of the court can make a complaint on his behalf. So that is always given a way out for such situation where it is not possible for the person to come in. Subsection 2 says, notwithstanding anything contained in the Sanghita, when any offense falling under section 356 is alleged to have been committed against a person who at the time of such commission is the President of India, the Vice President of India, the Governor of a state, the Administrator of a uh, Union territory, or a Minister of the Union, or of the Union or a state, or of a Union territory, or any other public servant employed in connection with the affairs of the Union or of a state, in respect of his conduct in the discharge of his public function. So anything we defamed against these people against the conduct of their public function, a court of session may take cognizance of such offense without the case being committed to it upon a complaint in writing made by the public prosecutor. So this is in these cases, when you are defaming their public function, they are not only defaming the person, you are defaming the role of the person as well. And that is why this is given a very serious place in the section, that in these cases, it can be taken by the instructions of the public prosecutor when he makes a complaint in writing. Subsection 3 says, every complaint referred to in subsection 2 shall set forth the facts which constitute the offense alleged, the nature of such offense, and such particulars as are reasonably sufficient to give notice to the accused of the offense alleged to have been committed by him. So whatever has been complaint referred in the subsection 2, which is against those people we have just mentioned, shall set for the facts which constitute the offense alleged and the nature of such offense, and such other particular are reasonably sufficient to give notice to the accused. So it has to be very crystal clear to give a notice to the person. Subsection 4 says, no complaint under subsection 2 shall be made by the public prosecutor except with the previous sanction of the state government. Now, the public prosecutor is not doing it because he or she wants to do it as per their own wishes, whims, and fancies. They are doing it. Why? Because there are certain guidelines which are given in this direction by the state government or the central government. So, of the state government, in the case of a person who is or has been the governor of that state or a minister of that government, or in the case of any public servant employed in connection with the affairs of the state. Similarly, for the central government in any other cases. So, subsection 5 says, no court of session shall take cognizance of an offense under subsection 2 unless the complaint is made within 6 months from the date which the offense is happened. So, there is a time bar. So, what is said? For these people, there is an exception. Court can take a cognizance with an application of a PP. The PP is putting that application because of the state or the central government has given such instructions in that directions already in terms of the sanction in those directions. But it has to be done within 6 months. There is no unlimited time which this can be done. This is also given for the sake of ensuring that there is no complaint which is made, which is for the other reason apart from putting a complaint. Because if somebody is smart enough, or somebody is aware of such an allegation, he would be aware immediately, and the person has to be making the complaint. Post 6 months or 1 year, 2 year, 3 years after, it might be the use case could be something else. It might be political perspective as well. So that is why, to keep it free and fair, it has to be within 6 months. You have a time to complain. Subsection 6 says, nothing in this section shall affect the right of a person against whom the offence is alleged to have been committed, to make a complaint in respect to that offence before magistrate having jurisdiction or the power of such magistrate to take cognizance of the offence upon such complaint. So there is no section shall affect the right of any person against whom the offence is alleged to take has been committed to make a complaint in respect to that offence before a magistrate having, there is no bar on that person also, or the power of such magistrate to take a cognizance of offence upon such complaint. So basically this is a cognizance restriction which is given by this section. But the requirement of a this basically subsection 1 talks about, in general there is a cognizance restriction except by the aggrieved party, or representation can happen for vulnerable people through somebody else. Special case of defamation, etc., is mentioned for so and so people. And then there is a complaint requirement procedure is also given, but it has to be operated very much into the framework given by the sanction of the state or the central government. And there is a time frame of is also given of 6 months, which has to be abided by, and it takes care of the right of the person who is accused also in such cases. When the complaint is made by the aggrieved person or by the public prosecutor, etc., etc., the section also clarifies that the right of the person who is alleged to have been um, can also file a complaint before a magistrate. So having a jurisdiction which remains unaffected. So against whom this offense is alleged to have been committed, that person also can make a complaint. So if I have been defamed and there is a provision where the provision is given automatic provision for a complaint through PP, etc., that can also be done. But that person personally also can make a complaint. So that is also which is allowed by the section, that the right of the person against whom the offense is alleged to have been committed is also free to make a complaint. The person can also make a complaint. That is no bar. Now let me go to the next set of sections, which is section 513 onwards. So in chapter 2, the third set of sections is second set of sections is 210 to 220 we've done. Second is 513 to 519, which is limitations to take cognizance. And then we'll, at the last, we'll see 227 to 233, which is commencement of proceeding before magistrate. So 513 to 519. Definition: for the purpose of this chapter, unless the context otherwise requires, the period of limitation means the period specified in the section 514 for taking cognizance of an offense. So what is the period defined in the section 514? Let's go to section 514. So section 514 talks about bar to taking cognizance after lapse of period of limitation, which is in general rule in case of most of the situations in the legal system where there has to be a limitation period which has to be respected. In the words of the Supreme Court also, the law is helpful to the people who are smart enough to challenge the uh, uh, the crime or the offenses against them in time. The person who is forgetful of that and the person who is lazy for that, the word lazy was used by Supreme Court. The person is lazy to defend themselves in those situations of offenses against them, etc., etc. The lawyers cannot be coming for their support, and that is where the limitation is something which is validated in all the situations of the practical applicability. So that is why there is a bar of taking cognizance after lapse of period of limitation. Section 514 says, except as otherwise provided in this Sanghita, no court shall take cognizance of an offense of the category specified in subsection 2 after the expiry of period of limitation. So what is that? The period of limitation shall be 6 months if the offense is punishable with fine only, 1 year if the offense is punishable with imprisonment of a term not exceeding 1 year, and 3 years if the offense is punishable with term exceeding 1 year but not exceeding 3 years. For the purpose of this section, the period of limitation in relation to offences which may be tried together shall be determined with the reference to the offence which is punishable with the more severe punishment, or as the case may be, the most severe punishment. So, for explanation, the section says, for the purpose of compounding the period of limitation, the relevant date shall be the date of filing complaint under section 223 or the date of recording of information under section 173, which is the police complaint. So what does this section is talking about? This is a section which is something establishing the rule regarding the time limits for prosecuting certain offences, stipulating when a court can no longer take cognizance of a case due to the expiration of the limitation period. Of course, this is in the condition which is a general condition. If there is some kind of exception, etc., that has been pleaded by for the leave of the court, but it cannot be too much diverting from that in your normal scenarios. So, subsection 1 talks about the general rule. It says that no court will take a cognizance of the offences which are after the period given in the subsection 2. So it says 6 months is the limitation period for any complaints to be made, which are the crimes punishable by fine only. 1 year for offences which are punishable by imprisonment for a term not exceeding 1 year. And 3 years if the offence is punishable with imprisonment for a term exceeding 1 year but not exceeding 3 years. So in all such cases, these limitations has to be followed. Subsection 3 talks about that in case when there are multiple offences and all of those could be tried together. So the period of limitation is then determined based on the offences that carries the more severe punishment. So the highest of them. This will ensure that the most serious charge is something which is dictate the timeline for the legal action, and it prevents the potential misuse of the shorter limited period. If it is otherwise round, it will be misused for lesser offences and negate the accountability of the person who has committed the crime. So we have also seen in one of the previous sessions that basically if the crime is of bailable and non-bailable offences, both person has been tried together, it will be considered a bailable offence. The way it is tried, it will be tried that way. Or if the there is a mix of petty crimes and the bigger crimes together, the limitations will be taken for the highest order of the crime, and then the relevant dates for the limitation period is explained at the end about that for the computing the period of the limitation, either the date of filing a complaint under section 223 or the date of recording information under section 173, which is something which will dictate the limitation period, and that is how it has to be done. So basically, if the examination of the is happening or if the complaint is made at the police station. So it encourages a timely prosecution. It gives a clearly a scale for different kinds of crimes depending upon the offense duration, and the limitation is given according to that, and then it prevents a claim which is too stale, because there might be not much interest itself into that incident later at that point of time. If it is going beyond that, it becomes useless for the courts also to operate that way. So commencement of a period of limitation. So basically what this section is talking about is the rules regarding the start date for the limitation period relevant to the offences, clarifying basically the period of limitation begins based on the various circumstances related to the knowledge of the offense and the offender. So basically, the period of limitation in relation to the offender shall commence how? A, on the date of the offense, or B, where the commission of the offense was not known to the person aggravated by the offense, or to any police officer the first day on which the offense comes to knowledge of such person, or to police officer, whichever is earlier. or when it is not known by whom the offense was committed, the first day on which the identity of the offender is known to the person aggrieved by the offense or to the police officer making investigation into the offense, whichever is earlier. And subsection 2 says, in computing the said period, the day from which such period is to be computed shall be excluded. So, when this talks about the commencement of the period of limitation. So, how do we do that? So, when it is the case when we know, so on the date when the offense was committed, that is something where the limitation period will start. That this applies when the facts surrounding the offense are known and acknowledged. So it's a case of a situation where things are very much known. The offense is known when it has committed. It has been committed. Offender is known, etc., etc. So in those cases, the most basic, the most standard cases, on the date of the offense, that particular limitation period will commence, will start. Number B, when the commission of the offense was not known to the person aggrieved by the offense or to any police officer, the first date on which the offense comes to knowledge to either of them, whichever is earlier, is considered the start of the limitation period. So I was traveling with my luggage, and my luggage, some part of it was stolen. So I came to know only on the third day when I was trying to open the bag, and that's the date where I went ahead and made a complaint the very next day to the police station. So on the 1st of January, I came to know for my travel on 27th of December. 2nd of January, I go and file a complaint in the police station. So 1st of January, which is the earlier date when the offense was come to be known to me, that is the date which is the commencement of the date of the limitation, not the actual theft which has happened on the 27th of December, a year back. Where it is not known by whom the offense was committed. Now, in this same situations could be extended to understand that I don't know who has committed. So the first day on which the identity of the offender is known by the person aggrieved by the offense or the police officer making investigation, whoever is earlier, whichever is earlier, is the date. Now, in this situation, I don't know. The police officer makes an investigation. He goes and looks into the CCTV records. And 5th of January, he comes to know about the person who has actually committed this crime of theft. He comes and tells me on 6th of January. So in this case, the first date is the 5th of January. The unknown person is now known that so-and-so person was indulged in this crime. So 5th of January in this case then becomes the first date of commencement. So in computing the said period, the day from which such period is to be computed shall be excluded. So on the day when it is being calculated, that has to be excluded, which is the basic thing. When that the starting day, the day when the limitation period begins, is excluded from the total count of the time limitation. I mean, this is how we count, right? So 1 to 5, we say 2, 3, 4, 5, 4 days, 5 days. So that is why the first day is excluded. So this means that the period of limitation does not include the day on which it starts. So that a fair consideration of time in the regular way how we do is calculated. Section 516, exclusion of time in certain cases. Now, we talked about exclusion of time in previous section. This section basically will talk about the specific situations where the time is excluded from the computation of the limitation period for taking cognizance of offences which are affecting the overall time frame within which the legal action must be initiated. So limitation period is nothing but there is a time period under which a legal action has to be done, and only within that period. So what is the exclusion of time in certain specific cases? Number 1, it says, in computing the period of limitation, the time during which any person has been prosecuting with due diligence another prosecution, whether in a court of first instance or court of appeal or revision against the offender, shall be excluded, provided that no such exclusion shall be made unless the prosecution relates to the same fact and is prosecuted in good faith in a court, which from defect of jurisdiction or other case of a like nature is unable to entertain it. What does it mean is, it says the time is excluded during ongoing prosecution. So the period of limitation may be extended for those who are actively prosecuting another case against an offender. Where such prosecution is conducted with due diligence, this applies that where the case is in court of first instance, appeal or the revision. In such cases, the period of limitation may be extended for those actively prosecuting under another case against an offender. So then it can be extended. So what is the condition for exclusion given here is the exclusion applies only if the new prosecution concerns the same fact and prosecuted in good faith. And the court which is handling the prosecution must be unable to entertain it due to a defect of jurisdiction or similar reasons. So in those cases, this provision will help protect the individual who are diligently pursuing their right in a separate but related legal matter. So if they are already engaged in a separate but a related matter, then they have to first free themselves from those particular matters and then come back to this person, which is also part of the related matter. So come back to this matter, which is also related matter. In these cases, in the time during which this person has been prosecuting with due diligence another prosecution, whether in this court of first instance or even in the appeal or for revision, in any of the cases, the matter is running. That is what is matter against the offender shall be excluded. So for that duration where he is engaged with the, why it is given as a similar related matter, because then it constitutes together a one unit of matter. As this is a related matter, it is a one unit of matter. It is broken down for the different related matters. It might be one of them is in the trial, it might be in the appeal, it might be in the revision, but sum total, if we see, this all is actually one single matter for the person related to one single incident which is related to it, and that is why he cannot be it's unfair that he is not given that time to come and free himself for that one first, and then the count will start. Subsection 2 says, where the institution of the prosecution is in respect of an offense has been stayed by the injunction or order, then in computing the period of limitation, the period of the continuation of the continuance of the injunction or order, the day on which it was issued or made, and the day on which it was withdrawn shall be excluded. So what is excluded? The day on which it was issued or made, and the day on which it was withdrawn shall be excluded. So what it says is, there is an exclusion again due to the injunction or different orders, which is subsection 2. That when the initiation of the prosecution has been stayed by an injunction or a court order, either way, it has gone into time freeze. The duration of that injunction or order is excluded from the limitation period because it is not the fault of that person who is making that complaint. Both the day the order was issued and the day it was withdrawn is excluded, which is we have understood from the previous principle also. When it is made, we remove that. Subsection 3 says, where notice of prosecution for an offense has been given, or where under any law for the time being enforce the previous consent or sanction of the government or any other authorities required for the institution of any prosecution for an offense, then it is computing the period of limitation, the period of such notice, or as the case may be, the time required for obtaining such consent or sanction shall be excluded, because that is something which is a procedural delay. That is where not active time is being spent by the person who is making that complaint. So what it says is, in notice of such prosecution has been given, and if the law requires consent, sanction, etc., those duration has to be removed, and the duration is subtracted basically from that. Subsection in computing the time required for obtaining consent, sanction, the government or any other authority, the date on which the application was made for obtaining the consent, sanction, and the date of receipt of order, like the previous one also. So in the fair way of calculating date and time, we remove those days. It is removed here also when such and such order or the such an application was made. Subsection 4 says, in computing the period of limitation, the time during which the offender has been absent from India or from any territory outside India, which is under the administration of the central government or has avoided arrest by absconding, concealing himself, shall be executed. Which means if literally if we see this particular section, we talked about the situation where the offender is unknown. In that case, the limitation period is actually unlimited until the person is found. So this is something which is saving the right of the person and brings a fairness in the legal proceeding for the person who's making the complaint, the petitioner. So it is giving a fair chance to the legal processing by not dividing him under the grinding of the limitation period. Because if we go just black and white from the limitation period without of his or her fault, they will lose the opportunity to uh, instate the particular legal reliefs which might be failing just because of the black and white reading and understanding of the limitation period in the previous section. So this talks about specifically the situation where such kind of situations could come to the person who is making such kind of petition and who is prosecuting the offender. That's where these are coming as a relief to the person. So subsection 1 talks about where he's already prosecuting the person in the related matter, not the in any completely different matter. So that case, that has to be reduced. Don't count the limitation period until that is sorted out. Then it is also talking about which is any kind of injection or any kind of time freeze through any order is done. That is also will be unfair if in that duration his limitation periods will expire. So that is why he's giving a relief to forego those number of days also. And number 3 also talks about that the person uh, who takes some kind of consent or some kind of government authority is required for filing such a complaint or filing any such kind of application. So that duration, which is a technical time duration, which is we know as per the government processes work, the person might have to make multiple applications, wait for multiple officials, provides multiple documentations and details, etc. It is unfair if the person loses in between that particular limitation period. And the last one is talking about when the person is absconding, absent, or the person is not available in India in that particular place, or when we talk about the cases which could be run outside India where we have a government arrangement and in those central government has given the instructions on the process, etc. That is also taken care by this section up to that extent that the person is not available, the offender is not available. In that case, waiting for the offender for that particular time period cannot be taken as a time period for the person who is offended, and that is unfair, and that is why that is also given in subsection 4. So which brings a fairness in the legal proceeding for the person who is being offended, and it encourages the persons to go to the court diligently and reinstate their rights without being worried about the loss of the time period of the limitation with no fault of their. So this is a protection against the delays which is not caused by the person himself or herself. And this comes very handy in most of the cases where there are people have multiple cases running and which are related to each other. And that is the diligent behavior of an advocate who knows about these sections to help the person get the relief without violating the limitation period, which is something which happens frequently in such cases, and get a relief for his client by claiming those exemptions. Section 517 talks about exclusion of date on which court is closed. So this is a completely logical and valid exclusion, which is something which is why it is kept in separately in a section. It's not a no-brainer actually that we need to speak much about this, that where the period of limitation expires on a day when the court is closed, the court may take a cognizance in the day on which the court responds. So a court shall be deemed to be closed on any day within the meaning of this section if during the normal working hours it remains closed on the day. So this is also valid in the other way around as well. If they are in between the counting of the limitation period, if there is a vacation which is coming and the normal court is not available, it is not listed during that, but it's not possible to list during that duration. In all those situations, the exclusion is which is a fair ask by the person who is aggravated, and the person will not lose just because the court is closed that day. So it will not fail the cause of the person who is offended, and this is a cognizance which has to be taken by the court that it cannot be counted. The definition of the court closure is also given, and it is encouragement of the timely prosecution of the person in spite of losing that one day because of the court closure. Section 518 talks about continuing offences. So, in the case of a continuing offences, a fresh period of limitation shall begin to run at every moment of the time during which the offence continues, which is again quite logical that the section is addressing a matter of limitation period in context of a continuing offences and clarifying how time frame for prosecutions are basically affected by ongoing criminal behavior. So a continuing offense is what? One that persists over time. It is meaning that the act or conduct of continuing the offense does not occur as a single isolated event, but rather continues to take place. For example, might include ongoing fraud by that person with the person, or illegal occupation of the place, or maybe continued violation of the law continuously, which is happening. And the person is not taking any, is no regard to the law, and he's continuing with that. Somebody comes and threatens every day the person on the door. So in that case, in the case of these kind of continuing offenses, the fresh period limitation shall begin on run at every moment of the time during which the offense is continued. And this again is applicable to the previous section, which talks about when it is known, subclause A, when the person is not known, subclause C, and when the person is known to the police officer, or the event is known to the police officer or to the person, subclause B of that section. So basically, this is a resetting of the limitation period every time the person, the offender, continues to go on committing the offense, and that is where it is giving fairly a chance of the person constituting the every instance of such crime against him a fresh lease of the limitation period. So this is a fair trial opportunity given to the person who is offended also, so that he is not uh, losing the limitation period and the person continues to doing it, is also being accountable that the limitation period, the liability continues to be there until he or she continues to commit the crime. Now, section 519 talks about extension of period of limitation in certain cases. So, notwithstanding anything in the uh, contained in the foregoing provisions of this chapter, any court may take cognizance of an offense after the expiry of the period of limitation if it is satisfied on the facts and in the circumstances of the cases that the delay has been properly explained. That is why I was talking about, or that is necessary so to do in the interest of justice. So, in spite of losing the limitation period, if you are going for a condemnation of a delay, as we say in the language of the court, and in case if it is something which is very valid to be explained, and please understand this could be something very simple also. I've seen it personally in some instances in Supreme Court also, where there was a delay of 25-30 days also by filing, where the advocate has actually delayed, and the reason given by advocate was she was in a delivery at that point of time, and which is also recognized by the court. So on behalf of the person also, you, if you are not doing it in person, and if there is a delay from the person who is representing you also, if there is a valid reason, so by law, in any reason which is feasible, normal, and which is in consequence of no such planning to delay the court proceedings, in those cases there is a condemnation of delay which is possible, and with the leave of the court, and this is a discretion of the court, this cannot be claimed as a right, but if the court is satisfied, the court can uh, agree on that delay and waive off those many days and consider the limitation day to be extended also, limitation period to be extended as well. So this is the extension of the period of limitation in certain cases, which is applicable in almost all the cases if there is a valid reason to explain that. So this is the last section in this set. Then we'll come to the next set of sections, which is section 227 to 233, which is commencement of proceeding before a magistrate. So let me go to that section. So we go to section 227, which is commencement of proceedings before magistrate. So now this section talks about issue of process. So if in the opinion of a magistrate taking cognizance of an offense, there is sufficient ground for proceeding and the case appears to be a summons case, he shall issue summons to the accused or for his attendance, or a warrant case, he may issue a warrant, or if he thinks fit, a summon for causing the accused to be brought or to appear at a certain time before such magistrate, or if he has no jurisdiction himself, some other magistrate having jurisdiction. So we have seen this condition in detail in previous discussions, where we talked about the magistrate can issue a warrant if he believes the person will not make himself or herself available, or summon only if he believes still the person will come and appear in front of the magistrate, or if it is in a different jurisdiction, make him through the some other magistrate having the jurisdiction, provided that the summons or warrants may also be issued through electronic means, which is a specialty of the BNSS. So it could be given through electronic means also. Subclause 2 says no summons or warrant shall be issued against the accused under subsection 1 until a list of the prosecution witness has been filed. So until such kind of list of prosecution witness which shows that authenticity of the matter, that the matter is authentic. Yes, there are people who are witnesses against in this situation. So no such summon or warrant can be issued until the so-and-so documents are listed and has been filed in front of the respective honorable court. And subsection 3 says, in a proceeding instituted upon a complaint made in writing, every summon or warrant issued under this subsection shall be accompanied by a copy of such complaint, which is the right of the person. We have discussed in detail earlier about that, that for why he is being summoned is something the person has a right to know. Subsection 4 says, when by any law for the time being in force, any process fees or other fees are payable, no process shall be issued until the fees are paid. And if such fees are not paid within a reasonable time, the magistrate may dismiss the complaint. So if there is a fee required, the court fee has to be paid. Otherwise, the magistrate may dismiss the complaint. Subsection 5 says nothing in this section shall be deemed to be affect the provisions of section 90. So what is this section talking about? So this section is talking about the outline of the procedure for issuance of a legal process by a magistrate upon taking the basic cognizance of the offense. So the magistrate has taken already an cognizance of the offense, and the legal process then would be initiated. And it details the type of the case, the requirement for initiating summon or warrant, and related procedural considerations of sending details along with the summon warrant and the court fee, etc., etc. But nothing in this section shall be deemed to be affect the provisions of section 90, which is issue of warrant in lieu or in addition to the summon. So the magistrate is free to issue a warrant instead of the summon or in addition to the summon, where the condition is the magistrate is in a belief that the person would not respect the summon at first place, he will issue a warrant even in a summon case, or the summon has been issued in either of the cases, warrant or summon, but before the time when the date and when the person is supposed to visit, if the magistrate is of a view that the person might not respect the summon, he can additionally issue a warrant. So that is also which is respected under section 90, is inclusive of in the section 207. So basically this is, once the cognizance is taken, then what happens? This is something which is the section talking about. So part 1 talks about when it happens, then the determination of the case is done by the magistrate, whether it's a summon case, whether it's going to be a warrant case, and accordingly he has to operate. So it's a summon case, he can put a summon, a warrant case, he can put a summon or a warrant, depending upon how it has to happen, depending upon the facts and how he's informed about the situation, or some other magistrate having jurisdiction if it is no jurisdiction to himself or herself. And this could be issued through electronic media, which is an added advantage to do it. While the subsection 2 talks about the requirement of witness list before any such warrant and summon could be issued, and any such warrant and summon could only be done when the prosecution's witness has been clearly filed. And it has to always, once it is issued, after that, it has to accompany the detailed documentation about all the reasons why this is issued. And by law, any kind of fees which is required has to be put inside. Otherwise, if the fees are not paid within a reasonable time. So reasonable time gives a help also and stick also. So in this case, the stick is where the fees is not paid, I'll reject. The magistrate has an option to dismiss. But help also, because reasonable time could be considered depending upon the considerate reasonable difficulties. While subsection 5 talks about the applicability of section 90, where the magistrate can decide of issuing the warrant at the first place or issuing a warrant additional to the summons. So this was the issue of the process, where the process is now being issued with the right type and method. Section 228 says magistrate may dispense with personal attendance of the accused. Now, this is something where the section will provide as the word says, with the direction to allow the accused individual or to be represented by counsel instead of appearing in person, and outlines the condition under which the personal attendance may still be required. So that is something which is written in the notice itself, or the warrant itself, or the summon itself. It is already written. If you see the lot of notices coming from such summons, etc., coming from the higher courts, mostly the Supreme Court primarily, they know it is not always possible for all the matters to the parties to appear. So they always say appear in person or appear through your advocate. It is clearly written there. Which means the magistrate or the judge, in that case, magistrate in this case, may dispense with personal attendance of accused. So whenever a magistrate issues a summon, he may, if you see reasons so to do, dispense with the personal attendance of the accused and permit him to appear by his advocate. Where this is done, obviously, is done mostly for the cases which are not of very complex criminal situations. But the magistrate inquiring into or trying the case may, in his discretion at any stage of proceeding, direct the personal attendance of the accused. They can also do. And if it is necessary, enforce such attendance in a manner herein before provided. So before we have talked about this, how the attendance can be made to happen. So this is basically a discretion which is given to the magistrate to allow the accused to come as in person or to be represented by advocate. So personal attendance or require come through an advocate representation, but the magistrate, it does not mean it's an ultimate decision. Magistrate, if required in the later part of the running of the matter, can at his discretion at any stage of proceeding can direct the personal attendance of the accused also. So that is also something which is enforceable also in case if it is not abided by. So this is a efficiency in legal proceeding, being very practical. If there is somewhere I don't need the person, why would I bother the person unnecessary? And it brings still an accountability to the head of the person that you, in spite of you not being called right now, if you are called, you have to come, otherwise you will be brought. Section 229, special summons in case of a petty offense. So petty offenses are very, very small offenses. So basically, this is a procedure for handling the petty offenses, which is given in this section, and allowing for a special summon to streamline legal process in case to promote the efficiency, the judge requires somebody to be present there, especially for those petty cases as well. So, subsection 1. If in the opinion of the magistrate taking cognizance of a petty offense, the case may be summarily disposed under section 283 or 284, the magistrate shall, except where he is, for reasons to be recorded in the writing or on a contrary opinion, issue summon to be to the accused, requiring him either to appear in person or by an advocate before the magistrate on a specified date. So either way, either he has to come himself or represent himself on the so-and-so date through an advocate. So before the magistrate, or if he desires to plead guilty to the charge without appearing before the magistrate, to transmit before the specified date by post or by message to the magistrate the said plea in writing and the amount of the fine specified in the summons, or if it desires to appear by an advocate and to plead guilty to the charge through such advocate, to authorize in writing the advocate to plead guilty to the charge on his behalf and to pay the fine through such advocate. So in all such conditions, it is the special summon which could be issued by the magistrate handling this petty matter, provided that the amount of the fine specified in such summons shall not exceed 5,000 rupees. So this is everything for a petty offense, which is really petty offense, which is limit capped at the amount of 5,000 rupees in the case. Subsection 2 says, for the purpose of this section, petty offense means an offense punishable only with fine not exceeding 5,000 rupees. So this is where it is capped, basically. And does not include any offense so punishable under the Motor Vehicle Act. Why? We have spoken it earlier also. Motor Vehicle Acts are separated because these are special MACT tribunals where these matters run, and under any other law which provides for convicting the accused person in absence of a plea of guilty. Subsection 3 says the state government by notification specially empower any magistrate to exercise the powers conferred by subsection 1 in relation to any offense which is compoundable under section 359, or any offense punishable with imprisonment for a term not exceeding 3 months, or with fine, or with both, where the magistrate is of opinion that having regard to the facts and circumstances of the case, the imposition of fine only would meet the end of the justice. So these are very, very small mischief, etc. In those cases, this is also done. Maybe electoral offenses also by the people on the booth making some mischief, etc., etc. So what is this section talking about? This is talking about special summon. So if basically a magistrate who concludes that a petty offense can be swiftly resolved as per the provisions of the section 283 or 284, and they shall issue a summon to the accused unless the magistrate records in a writing reason for a different approach. So if a different approach has to be taken in a petty offense, then it has to be recorded. Otherwise, he is free to do that the summon requires the accused to either he can issue the special summon to appear in person or through the advocate on a specified date in a specified court, or if the accused wishes to plead guilty without attending the person, they can send a written plea on the specified and the fine to the magistrate and or the messenger, which is the advocate. So through that, they can also plead guilty and pay the fine. So if either the opportunity is given for them to come in person or through advocate, or plead guilty, pay the fine, because the plead guilty will not cause you any punishment. In this case, this is only punishable by fine up to maximum 5,000. So by pleading guilty will only cause you a financial loss of not more than 5,000. So there is a limit of that. Why there is a limit of that given? Because this is the limit given to the petty offenses. Definition of petty offenses is also given in subsection 2, and it excludes the Motor Vehicle Act or any such special act which is as instructed by the government to be handled that way, other way around. Subsection 3 talks about the empowerment of the magistrate to the state government may issue special notification to give a specially empowered to any magistrate to exercise this power, which is given under subsection 1, and which is for a term of imprisonment not exceeding 3 months or by fine. So any special magistrate can also be given such kind of power to resolve it only by fine if it makes the justice and the social impact high on this situation. So those magistrates could be specially empowered by the state government by notification that yes, you are allowed to resolve it only by fine up to 5,000 also, in spite of there is a provision for this being of a punishment of until 3 months of time. So this is section 229. So this is something which is a very good thing brought by BNS section 230, supply to accused of copy of police report and other documents. So this is very, very important in terms of a fair trial, and the person should know why he is being executively prosecuted, etc., etc. So in all those conditions, this is the right of the accused which is safeguarded, and the accused can also receive a copy. So in any case where the proceeding has been instituted on a police report, the magistrate shall without any delay and in no case beyond 14 days from the date of production of appearance of the accused, furnish to the accused and the victim, if represented by an advocate, free of cost a copy of each of the following: the police report, the FIR, which is section 173, it was 156 earlier, the statement recorded under subsection 3 of section 180 of all the persons whom the prosecution proposes to examine as its witness, excluding therefrom any part in regard to which the request for such exclusion has been made by the police officer under section 7 of 193. So let's stop here and let's go back. So any case where the proceeding is instituted by police report. So then when there is a police report is instituted under 173, the magistrate will offer without delay within 14 days these copies to both victim and the accused. So victim, it was always there. Accused is added now. So what he can receive the copy of the police report, which is the charge sheet, the FIR, which is 173, the any statement of any witness, etc., which was statements are required under 180, and the prosecution which of the witnesses whom they are planning to examine, but excluding which is subsection 7 of section 193, where the police officer has gone back and made an application to the court that this is some confidential document which should not be shown to the accused and which will cause an injustice or difficulty in the execution of that particular judgment or justice system for that particular matter. And if the court is allowing that, then that will be not provided to the accused. Number 4, the confession and the statement, if any, recorded under section 183, also a copy has to be given, and any other document or relevant extract thereof forwarded to the magistrate with the police report under subsection 6 of section 193, that also can be given, provided that the magistrate may, after pursuing any such part of statement as is referred in clause 3, which is to hide anything, and considering the reason given by the police officer for the request, direct that the copy of that part of the statement or such portion thereof as the magistrate thinks proper shall be furnished to the accused. If the magistrate is not agreeing to what the police officer is requesting, that copy will also go to the accused. Provided further that if magistrate is satisfied that such document is voluminous, he shall, instead of furnishing a hard copy, he can also provide a soft copy. So may furnish the copies through electronic media. A PDF file will be given. So he will only be allowed to inspect the hard copies either personally or through advocate in the court. If it's a very big document, they can plan to give it soft copy. Now, why this is given? Because nowadays the e-filing happens and the soft copies are there in provision of the court, which could be provided very easily to the accused because it's already available there. So provided also that supply of documents in electronic form shall be considered as duly furnished. So it does not mean that only the hard copy stamped saying that the copy has been given is considered it to be furnished. Also the sending of the soft copy, which is mentioned in the second proviso of the subclause subsection 1, is also something which is agreeable and which is acceptable. So what is this section basically talking about is, it talks about basically the provision of copies now also to the accused persons or person, and what all copies could be provided. Then there could be one reason why it could not be provided to the accused is where the police officer continuing with the investigation might want that to be hidden. And in that case, that's a discretion of the court. If the court is satisfied, it will not be provided. If not, then it will be provided to the person still. And under section 193, subsection 7, if that is an application made, it's a jurisdiction of the court to allow it or not allow it. And any kind of statements taken by police under section 180, which could be something which is allowed, and even the confession statements under 183 is allowed to be given as a copy to the accused. So, nutshell, everybody gets a copy nowadays free of cost within 14 days, whether you are accused or a victim. And if there are some exceptions requested by the police to not to show to the accused those papers, it's a discretion of the court, and the court might decide to give it a soft copy or a hard copy. Either way around, it is considered to be duly furnished. Section 231. Supply of copies of statements and documents to accused in other cases triable by court of session. So now we are talking about such situation in the sessions area. So where in a case instituted otherwise than on a police report, it appears to the magistrate issuing process under section 227 that the offence is trialable by the court of session. The magistrate shall forthwith furnish to accused the free, free of cost a copy of each of the following. The statement recorded under section 223 or section 225 of all persons examined by the magistrate. Now, this is a situation where we are talking about not on a police report when the case was instituted and somebody has filed a criminal application in the court of the magistrate. And the magistrate has done the examination of the complaint, which is under section 223, or postponement of the issue of the process in case he is not satisfied. So what he will do is he will examine. Once he examines under 223, if he is happy, then the statement recorded under 223 will be provided, or 225 if the magistrate feels it is not something which is apt and appropriate to continue and he wants to discontinue the process, he will provide a statement recording under 225 with the reasons, and all persons examined by the magistrate, the detail will be for 223 available. So this is something free of cost. This copy will be given. The statement and confession, if any, recorded under 180 or 183, if in case any statement was recorded by the police, etc., then those things or the confession, etc., has been made. So those things also has to be provided. Any documents produced before the magistrate on which the prosecution proposed to rely. So the complainant, the prosecutor who has bring in that matter, if he has given any other document which he is want to rely further, and which is a document which is presented to the magistrate, so that also, provided that if the magistrate is satisfied that any such document is voluminous, same thing, he can provide a soft copy, and provided that supply of the electronic form should also be considered duly framed. So this is a specific case, in general case, where the default original jurisdiction of if the session cut is not understood, is not the situation, and the matter is with a magistrate, and the magistrate believes that this is trialable by exclusive by the court of session, and then the magistrate shall forthwith furnish to the accused these copies before it goes to the session court. Section 232, which is a commitment of case to court of session after when offense is trialable exclusively by it. Now we were talking previous section about the offenses which are moved by the magistrate and considered to be done by the session court. Now, commitment of cases to court of session when such offense is trialable exclusively by it. So when in a case instituted on a police report or otherwise, the accused appears or is brought before the magistrate. Now the magistrate, as it appears to the magistrate, the offence is trialable exclusively by the court of session, like previous section, and he shall then what he will do. So first, previous section was talking about in this scenario what happens to the documents which is with him. So in those cases, what happens? Now, if it is how the commitment happens. So A, commit after complying with the provisions of section 230 or section 231 the case to the court of session and subject to the provisions of the Sanghita relating to bail, remand the accused to custody until such commitment has been made. So this is which is talking about that commit. Commit is the act of sending that matter with all the reasons to the session judge that it has to run in the session court now. So after complying with which is done with the provisions of section 230 or section 231, which is 230 is about supply to the accused the copy of the police report, etc., and all other document, or supply of copy of statements or documents, etc., to accused in other cases trialable by the court of session. So either of the case, whatever copies have to be first given to the accused, and then it has to be committed to the session court. Now, the commitment and the actual the matter coming to the board of the additional session judge, it might a time period between that. In those period, and is subject to the provision of the Sanghita relating to bail, remand the accused to custody until such commitment has been made. So then, in that case, the magistrate still has a power to remand the accused to custody until such bail, and if related to bail, whatever is provision to be acted upon. Subclause B says subject to the provisions of the Sanhita relating to bail, remand the accused to custody during and until the conclusion of the trial. So he can still have the authority to do that. Send to that court the record of the case and the documents and articles, if any, which are to be produced in evidence. So everything has to be transferred to that particular court, which is the additional session court judge, additional session court and his judge, his court, which is identified. Notify the public prosecutor of the commitment of the case to the court of session. So he has to be notified, provided that the proceeding under this section shall be completed within a period of 90 days from the date of taking cognizance. And such period may be extended by the magistrate for a period not exceeding 180 days for the reason for which is recorded in writing, and provided further that any application filed before the magistrate by the accused or the victim or any person authorized by such person in case triable by court of session shall be forwarded to the court of session with the committal of the case. So any application which is filed before the magistrate by the accused or the victim or any other person authorized in a case triable by court of session shall be forwarded to the court of session with the committal of the case. So that application, if it was made, also has to be sent. So this is basically determination of the jurisdiction which is happening, and commitment is happening to the session court. So the subsection 1 ABCD says that the magistrate shall either, the magistrate will commit the case to the court of session after complying by giving the copies to the accused, and so that the accused may be remanded to the custody pending his commitment and subject to the provision. That can also be done. Remand the accused to the custody, not only during the commitment process, but also throughout the trial also. Still the jurisdiction and the court is allowed until the trial duration is concluded, and provided it is comply with the relevant bail provision, if it's as per the bail provision, if the court is allowed to have an etc. etc. Send the complete record of the case of the court to the court of the session, because you're passing on the case, you have to pass on the document also, and so that the higher court is completely aware of the relevant material already with the lower court, and notify the public prosecutor that it has moved there. But then they have to follow the timeline in the first proviso, which talks about the within 30 days, 90 days you have to do, or max 180 days the magistrate can take, but with a reason which is very well could be explained. And the forwarding application by anybody, any of the parties which is done, those applications also has to be forwarded to the court of session during the committal of the case. Last section in this chapter is section 233. So, procedure to be followed when there is a complaint case and a police investigation in respect of the same offense. So, when in a case instituted otherwise than on a police report, hereinafter referred to as a complaint case. So, the complaint case is there. It is made to appear to the magistrate during the course of the inquiry or trial. So, when the initial inquiry is being done, or in course of the trial which is running, that an investigation by the police is in progress in relation to the offense, which is the subject matter of the inquiry trial held by him. So, there is something which is already running by the police. The magistrate shall stay the proceeding. So, basically, in this case, when in section 233, the procedures which is where the complaint case is running and the police investigation is respect of the same offenses, which is something which is brought to the notice of the court. Now, this is something where the court will then in this inquiry or at the stage of the trial also, when the matter is running, can put a stay in the proceeding of such inquiry or trial and call for the report of the matter from the police after conducting the investigation. Now, if there is already an investigation running from the police and this matter has come to the court, anyways, the court would have done some inquiry or would have asked for investigation by the police. Now, if it comes to the notice of the court under subsection 1 that there is already a police investigation running, and then in that case, at whatever stage the court is, they will immediately stop the proceeding. The court will stop the proceeding, and such inquiry or trial, whatever is happening, then it will first call for the report of the matter from the police officer who is conducting the investigation, which is the investigating officer. Subsection 2 says if a report is made by the investigating police officer under this section 193, and on such report, cognizance of any offence is taken by the magistrate against any person who is an accused in the complaint case, the magistrate shall inquire into or try together the complaint case and the case arising out of the police report together, as if both the cases are instituted on a police report. So it is where it was a complaint case where it was instituted through a complaint, not through a police complaint, not through a police report, etc. So if in the lifetime of that particular case running in the court of that magistrate, if it is asking for a police report, as it has come to the cognizance of the court that the investigation is already on in that matter, in that case, the police court will ask the magistrate to, if they will order to submit the report. Once the charge sheet, etc., is submitted to the court, and then the court is relying on that also, then although this was initiated by the complaint case, although the police report came later, but then the court will try together the complaint case and the case arising a police report as if the case were instituted on a police report. So it will then considered as a police report, because now the police report is also in picture. And subsection 3 says if the police report does not relate to any accused in the complaint case, or if the magistrate does not take cognizance of any offence to the police report, he shall proceed with the inquiry trial which was stayed by him as per the provision of the Sanhita. Now, 2 and 3 gives a switching effect between the original complaint case. If he takes a cognizance, if the magistrate believes on the report and he thinks it is fit for that particular matter, and the accused is part of the police inquiry itself, then the police report is given prevalence and it is considered police report based complaint. In case the court does not seize the name of the accused in the complaint case of the police, or it does not take cognizance of the offence on the police report, which is what there, in that case, it is something which is not reliable or not usable in this particular matter. In that case, then the court will then conduct it as business as usual as a complaint case as per the provisions of the Sanhita. So this is what is the section 233 provisions.